Hey Spice Tea Fam, Tea here. Welcome back to my channel, or if you're new here, welcome. So I got a good one for you today. A defendant's pretty desperate of wanting help, not wanting to go to prison, but he has, I think, 5 possession of methamphetamines felony. So the judge is just like, what the hell? No. And his attorney makes some great points. I'm not gonna lie, this really brought a couple tears to my eyes because you guys all know I'm in recovery. And, you know, I just felt for the guy. But again, he's awaiting sentencing. He was arrested again. But then you hear, okay, you're picking up new charges while you're awaiting sentencing. How dumb. How dumb. But then you hear that these charges happened prior to this case and they just happened to file. I believe it was one of the instances. I think on both. I'm not sure. So yeah, it brought back a lot to me. I feel bad for the guy, but at some point, what is somebody supposed to do? Like, obviously, you've been struggling with this. You keep getting charges of possessing meth. So my only option is to remove you off the street to separate you two. And, you know, it's unfortunate. But we all know that defendants will promise and lie and say anything and everything just to get out of it. I did it. You know, I can't tell you how many times I've lied to a judge or try to manipulate the judge, bring on the tears and the family, and you know, we all do it. I'll just let you guys watch it. You guys can form your own opinion and we could discuss it in the comments. But before I start the video, please like and subscribe, turn on your notifications, that way you don't miss an upload from Spicy Tea. But without further ado, let's get into the video.
It's case number 2024-CR426. Brett Sweeney appears for the state of Kansas. Joseph Favre is defense counsel. Scott Andrew Weinbaugh appears at the court security Zoom location located at the Butler County Judicial Center. The defendant had appeared before this court on January the 23rd of this year. At that time, he pled guilty to possession of methamphetamine, a level 5 drug felony. The pre-sentence report was ordered, with sentencing originally set for March 14th at 11. The docket notes from March 14, the original sentencing date, indicate that the defendant requested a continuance to allow for a departure motion, which was not opposed. Sentencing was reset to today. Defendant was ordered to appear at the Judicial Center again. We're before the court at this time for sentencing. I trust the state's ready to proceed.
Yes, Your Honor, the state's ready to proceed.
And the defense is ready to proceed, Mr. Favre?
So, Judge, we are not quite ready. We're actually going to ask for one more continuance of this sentencing, which is a very odd request given that we've been here before. But there's been some intervening things that have happened since we were last before the court. Mr. Weinbaugh did indeed go get a drug and alcohol evaluation. I did not know that because I had not received it, but apparently he did get one at 7th Direction. And apparently I just never received it. He also got arrested in the intervening period, and there's been new cases filed that have changed kind of the complexion of where he is overall. I've spoken to Mr. Sweeney about that, and we're exploring some options here, but I would like to request another 30-day continuance. I know that we've already done that, but I'd like to get a departure motion properly in front of the court. If we're going to go that way with his new cases, we may end up not going that way, but either way, we will be ready to go in 30 days. We just need some time to kind of make that happen. And his being in custody until yesterday has kind of delayed the ability to prepare that motion that we would need.
Why was he in custody recently, Mr. Favre?
He had a new case, Judge, that he had picked up. He was arrested on, and
and I presume there's some sort of known charges that were associated with that case?
That is correct, Judge, yes.
What was it?
Similar in character to this. It's possession of methamphetamine.
All right.
Is the allegation.
Right, because my office was notified that Mr. Weinbaugh had very recently been released back on bond, which struck the court as odd because to this court's knowledge, he was on bond in this case. So he shouldn't have been in custody on this case. So apparently it was going to be something else. All right. Does the state take a position regarding this second continuance request?
Your Honor, I spoke with Mr. Favre. I let him know that I don't have enough. Is the court hearing me?
I am.
Okay. I spoke with Mr. Favre. I let him know that given kind of the very unique situation that we had going on here, and then 2 new felony cases, the state would not object.
Utah must be way different because I tell you what, if I had a felony possession and I was out on bond and they filed new charges, regardless if it was prior to this charge, if they filed new felony charges of possession or just if it was a felony, you wouldn't go back on bond. So that tripped me out that he was released back on bond after new charges. Because Utah, you're felony on felony, so you wouldn't even get bond. And that's how one county works. I want to say both counties. I'm not sure, though. But Weber County, I definitely know that they're felony on felony, so that would never happen. You would never get back out of jail if you had a felony and then got arrested again on a felony. So it was wild to me how different places are.
Well, I understand that. I understand the state's position and I understand the defense position, but this court feels like it would be rewarding a lack of diligence to stall and delay this felony sentence for a second time. The court's just simply not inclined to do it. The fact that he's got new cases should not influence the final resolution of this one. And I understand there may be some strategy that's involved here with new pending cases, but this is a case that's already been resolved by plea. It's ready for sentencing. The court has before the pre-sentence report, and the court had already granted a continuance of 4 weeks for purposes of filing a written departure motion. The court's going to deny the continuance request. We're going to proceed to sentencing on this matter today. I do understand to a certain extent, Mr. Sweeney, you're compromised by the lack of a filing of a written motion because you don't know exactly what you're going to have to counter. If you do take a position regarding a departure request, the court will, in fairness to the defendant, allow defense counsel to make any arguments that he feels are appropriate in support of a departure sentence, and the court will consider those. But as far as delaying this sentencing again, the court declines to do so. The continuance request is denied. We'll proceed with sentencing.
Can I say something, Your Honor? I don't know why my attorney has not received information from Seven Direction. I signed a waiver to release all information to Mr. Favre. And then that was the Thursday, and I even scheduled for drug and alcohol assessment, the assessment with the classes, and was started enrolled in them that following Monday after I did my evaluation here in town at Seven Direction with Cindy. Like I said, I don't know why he has not been notified on that, and that's why we were kind of asking for the continuance. So
the position is noted by the court. Mr. Weinbaugh, we're going to proceed further with sentencing in your case today. All right. The court has before it the pre-sentence report that would indicate criminal history in the case. Does the state object to the criminal history as stated in the report?
No, Your Honor.
Does the defense object to the criminal history, Mr. Favre?
No, Judge.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Other than what has already been discussed, is the state aware of any legal reason why sentencing should not be pronounced in this case at this time?
No, Your Honor.
Mr. Favre, do you know of any legal reason why sentencing should not be pronounced in this case this afternoon?
No, Judge.
Weinbaugh, do you know of any other legal reason or any other good reason why the court shouldn't proceed with sentencing in your case today?
The reason why I was continued last time was you guys were waiting for my drug and alcohol evaluation, which I did do that here in town at Seventh Direction. I just don't know why they didn't relay the information to my attorney. Like I said, I'm doing everything like I was supposed to do. You know, I went to my classes Monday, Tuesday, Wednesday, and that's where I'm at on that one. Like I said, I don't know why.
You say you guys. This court didn't order you to do anything. It
right,
could be that it's a matter of strategy in regards to sentencing. You and your attorney discussed something, but
the only thing you guys were waiting on me to do was just the evaluation, the drug and alcohol evaluation, and I did do that. Like I said, I don't know why Cindy hasn't faxed over any of the information. I don't know. I signed a waiver to release all information to my attorney. Like I said, that's why we were waiting, or that's why we were trying to do a one more continuance, just so he could get in contact with her. Because like I said, I don't know why they haven't contacted each other. I signed the waiver. I don't know why.
I think the judge understands that, Mr. Weinbaugh. We're going to have to proceed with sentencing today.
Mr. Weinbaugh, your plea was entered back on January the 23rd. We're now well into the month of April. Seemed like that there was more than enough opportunity that if somehow you and your attorney felt strategically a new substance abuse evaluation was going to be helpful to the defense case, that should have been scheduled, completed, reported, and in this court hands well before today.
Yes, sir.
So your comments are noted, but once again, the court will proceed further with sentencing in the case. We're noting that there is no real victim is associated with this offense. There's no victim or members of a victim's family to address the court. At this time, the court will proceed with recommendations from counsel regarding an appropriate sentence for Mr. Weinbaugh, starting with Mr. Sweeney on behalf of the state. Okay, you're muted, Brett.
I'm sorry, Your Honor. Your Honor, pursuant to plea agreement, the state is recommending the standard in mid-box 20 months in the Department of Corrections. The defendant would be eligible for the maximum good time percentage of 20%, as well as the post-release supervision duration of 12 months. At least as it relates to this case, I think it's accurate that he has 1 day of jail time credit. Your Honor, there is a special rule that makes this case presumptive prison. That's the third strike. It's my understanding that the defense will make a departure motion, and the part of the plea agreement in this case is that the state would stand silent on the same. As far as costs and fees associated with the case, Your Honor, the state is not requesting a fine. We are requesting $400 payable in restitution for the KBI laboratory report. Any other standard costs or fees, of course, the court cost. And then would ask the court to take a look at bids and attorney's fees if the court finds those appropriate as well.
Very well. Thank you, Mr. Sweeney. Mr. Favre, you may make recommendations regarding an appropriate sentence. Please include any arguments that you would otherwise make in support of an oral motion for a departure sentence.
Yes, Judge. Essentially, the basis of the departure motion in Mr. Weinbaugh's case is that Mr. Weinbaugh has a fairly minimal criminal history. He's got 2 prior felonies. They're both, three prior felonies. They're all drug related. Mr. Weinbaugh has 6 entries in his criminal history worksheet. 5 of those 6 are substance related, the other being a disorderly conduct from 2005. So he is in as close as we can come, essentially, basically just a criminal because of his addiction. And that is something that, you know, in society, we talk about what is the proper way to handle addiction. Is it proper to, you know, criminalize and send people to detention for that? And Mr. Weinbaugh, you know, is a person that has not had many other societally disruptive behaviors that we frequently see with people that have drug addictions. And that's borne out by his criminal history. As he mentioned, he has made efforts to get into treatment to try to address his addiction in the community. His last conviction was 2018, I believe. So he is not a person that has been just perpetually in trouble in the recent history. He thinks he can be successful in the community. He started attending, as he said, classes with Seventh Direction with Miss Arnold after he got the evaluation. That's based on what he's telling me. I've not seen that, but I don't know why he would be lying about that. He does work. He did work prior to this most recent incarceration at Wendy's. It's worth noting that even these new cases, they are both for a substance abuse issue. Like the first one is an old case that was filed by the state prior to this case. It was a 2023 case that just recently got filed. The other case was the one that put him in custody, which was a stop in early April of this year. And that case is recent. It's for a small amount of methamphetamine, allegedly. He's still presumed innocent on both of those cases. We'd ask the court to weigh the evaluation of the input of those new cases properly, given that he's still presumed innocent. We think there's a substantial and compelling reason to grant people the option to stay in the community to receive treatment when they have demonstrated that that's what they desire, and especially when there's hope that the person is going to be able to do it because they've taken steps to that effect, which Mr. Weinbaugh has. And also, particularly when they have a record of showing that even in their addiction, they're not really a danger to the community. If you take Mr. Weinbaugh and place him in DOC, there's a hard argument to make that the community is much safer. He really hasn't been much of a threat to the community. So I think it's worth giving him the opportunity to try to pursue his efforts in the community to try to address his addiction. So for those reasons, we're asking the court to grant the departure.
I lost your video, Mr. Favre.
I lost my video too. Sorry. Where'd my video go? We asked the court to grant the departure and place Mr. Weinbaugh on community corrections probation for a period of 12 months, standard conditions. We agree with the underlying recommended by the state as well as the jail time credit recommended by the state. No objection to the costs and fees, with the exception of we asked the court to consider waiving his attorney's fees because even though he is employed, it's at Wendy's. He doesn't make much money at Wendy's, so asked the court to take that into consideration.
So what you're seeking here is a dispositional departure to probation, correct?
Yes, Judge, that's correct.
And I do want to ask, especially under the circumstances of this case, anything further, Mr. Favre?
So, Judge, I will tell the court I have not received anything from Ms. Arnold. Mr. Weinbaugh has been in good communication with me generally prior to his arrest, but because he was arrested and in custody for a while, I had not had communication with him recently. So I have no reason to doubt that he's telling me the truth about his evaluation with Seventh Direction and the treatment that he's been attending post that evaluation being completed. So I'll just add that as well.
All right. Thank you, Mr. Favre. Mr. Favre, according to the criminal history currently before the court, this is the 5th Kansas county in which Mr. Weinbaugh will be sentenced. Should this court presuppose that in the previous 4 counties' cases, all dealing with substance abuse, that he's never been required to have an alcohol and drug evaluation and never been given an opportunity for treatment on any of his prior cases, especially his prior felonies?
So, Judge, I would not make that presumption. I do not have a detailed list, of course, partly because I don't have the evaluation of what his prior treatment efforts were. I would make the assumption that he has had prior treatment, but I think it's worth noting that these cases that he's had, they're not back to back to back. So I think it speaks to the fact that he's probably had periods of success and sobriety. And as the court knows, sometimes it just takes a while for sobriety to take maturity, and the tools take some time to develop. So even if he's had it before and has had success and failure, this may be the time when he's ready to have that success. His indications seem to be that way. And like I said, there's very little indication that him being in the community is going to be a danger if we give him that chance.
How much are your fees in the representation of this client?
Should be $1,100, Your Honor.
All right, thank you. Mr. Sweeney, under normal circumstances, I would give the state an opportunity to respond to the oral departure motion that was made here for the first time, but given the state's commitment to remain silent in regards to the departure motion in the case, I'm not going to ask you for any additional comments, as it would be violative of the plea agreement in the case. So at this time, then, the court will address the defendant, Scott A. Weinbaugh, personally. And I'll ask Mr. Weinbaugh, do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court?
Other than, I just started my classes. Literally, this will be the 2nd week of me being in them. Give me a shot. Let me try it out. I mean, I can do it. I know I can. I've held a job at Wendy's for the last year, and then right before that I worked at Arby's here in town in El Dorado for a year as well. I mean, I can hold a job. I mean, I can do the classes as long as they put me in the right class for my work schedule, because the morning classes just weren't going to work, because I get off work at Wendy's about 1 in the morning every night. So then having to be in class at 8:30 just, you know what I mean, it wasn't going to work. So I have to tell my job, I can't go to work till 8 o'clock Monday, Tuesday, Wednesday, because I have night classes from 4:30 to 7:30 here in Seven Direction in town. I just started it. I think I'm doing a great job. I mean, I like them. I mean,
Anything else, Mr. Weinbaum?
no, sir. I mean, other than, just let me continue working with Seven Direction. I mean, Cindy seems like a great counselor. I just met her, and I'm actually working in my classes, participating and all that stuff, and also holding a job at the same time. That's about it, sir. I mean, I know I can do it. Just nobody's given me really the opportunity. On all my other past experiences, it was always, you know what I mean? Go to, just here's your sentence, and then ended up going to the joint. And that's all. And I mean, to me, it's hard to do anything like that. I mean, I'm actually getting the opportunity to do the Seventh Direction, you know what I mean, and hold down a job in the public's eye. I work at Wendy's, sir, here in town, night shift. Like I said, I close that down every night, and I've been doing that for a year. I've got great people who I work with, who ended up being my good friends, who've been there throughout this little experience that I'm going through right now. I have a great girlfriend right here next to me. I've got a 9-year-old niece, and she's been my rock, and vice versa. And I know if anything happens to me now, she's gonna look at it like I failed her. And I made a promise to her that nothing like that's ever gonna happen to her again. But if I go to prison, I lose that little girl's heart.
Mr. Weinbaum, when did you actually enter into your most recent substance abuse program?
What was it? The 11th, I do believe, is when I had my drug and alcohol assessment done. And then I scheduled it for that following Monday. I started classes. What was it? Last month on the 11th is when I had my drug and alcohol assessment scheduled for here at Seventh Direction. And like I said, that same day, that's when I enrolled myself into treatment. And it was 3 days a week, 3 hours here in town, just a couple blocks from the house, so I can walk there if needed. You know what I mean? Like I said, and I just started that. And like I said, Cindy's a great counselor. That's where I'm at with that, sir. But yeah, it's Monday, Tuesday, Wednesday is when my classes are. I can either go 8:30 in the morning till 11:30 in the morning, or the afternoon classes are 4:30 to 7:30. And I originally set up for the morning classes, but then that first day I was like, man, Cindy, this isn't going to work. I need to go to the night classes, because like I said, with me getting off of work at 1:30, almost 2 sometimes, leaving Wendy's after I close it up and clean it and all that, being in class at 8:30, it's hard to be fully attentive, I should say, and that's why I switched to going to the night classes, where I could make sure that, you know what I mean, I'm fully awake and all that, and participate, which Cindy didn't have a problem with me doing, just as long as I appeared Monday, Tuesday, Wednesdays. So, like I said, I mean, Monday, granted how this all goes, Monday I was going to be there, and for my classes for the next 2 days, well, till Wednesday, and then I'd go back for the next week. And like I said, this is all here in town in 7th Direction.
Very well then, Mr. Weinbach. The court will pronounce sentence in this case at this time. Before I do want to point out, Mr. Weinbach, that I've considered the remarks made by your attorney in support of a departure sentence in this case. I also note that the state is standing silent on that request. With that said, the court hereby establishes count 1 as the base sentence in this case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of E, thus placing him in grid box 5, drug E. The court hereby sentences the defendant to a term of 18 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. This court does note that a special rule applies to this case. That special rule is this is a third or subsequent felony drug possession. It is presumed prison under KSA 216805 F1. It is therefore the legislature's intention, Mr. Weinbach, that someone essentially with your criminal history, with the record of felony drug possessions, goes to prison. In fact, the language of the statute says there shall be a presumptive term of imprisonment and the defendant shall be sentenced to prison as provided by this section. Now, the legislature also envisioned in that same statute that there would be a facility set up to provide treatment, and that treatment-oriented facility, after at least 4 months there, you could be returned to the court for reduction or modification of sentence, in essence. But the legislature's never funded or set up that facility. That's regrettable. But we have a situation here, Mr. Weinbach, that you simply will not stop your relationship with methamphetamine. You've got a long-standing history of use of this very dangerous street drug. And even when your case was pending for sentencing before this court, it would appear that you've at least been arrested and at least potentially accused for that once again. Now, you haven't been convicted of it. But it's disturbing to the court that you would have drug-related contact with law enforcement. Furthermore, Mr. Weinbach, the evaluation, should it be sent to this court, would likely review your history and then say you have a serious possession of methamphetamine problem and you need treatment. And then they would recommend a treatment modality for you. But I asked this question of counsel earlier before. This is the 5th county that you have been sentenced for a drug crime for. I just find it really hard to believe that you haven't had a full opportunity for an extensive substance abuse program. And for whatever reason, whatever you've been offered before hasn't worked. You just simply will not separate yourself from this drug. And of course, when people are before a judge for sentencing on a felony, they make all kinds of promises and commitments about what they're now willing to do. But you haven't been willing to do these things in the past, Mr. Weinbach. There's absolutely no reason for this court to believe that things will be any different if you're given yet another chance pursuant to a departure case. And the court does not find that there are substantial and compelling reasons here that would support a departure. It's the same old thing. We're going to give you an opportunity for community-based treatment. And with your record of failure and your record of constant through your adult life use of methamphetamine, it would appear to this court that you need to be rescued from yourself. The only way that you can be separated from this street drug is get you off the streets. And it's regrettable, Mr. Weinbach, but the court's going to note here that this is a third or subsequent felony drug possession, that the Kansas legislature has determined that this is a presumptive prison case, and the court will order the presumptive prison sentence. Now, the court has listened to the arguments of counsel in this case and granted you the mitigated sentence of 18 months. But Mr. Weinbaugh, the court's ordering you into prison today to serve that 18 months. And any of the family considerations that you've had out there, again, the court hates to separate you from family, but you separated yourself by your constant bad judgments and decision-making about the involvement with this dangerous street drug, methamphetamine. And you chose methamphetamine over your family. And that's a shame, Mr. Weinbaugh. But those two, in the view of the court, are not compatible. So you need some time away. And that's what the legislature envisioned, and that's what the court will simply order today. And the court does order the presumptive prison sentence of 18 months in Department of Corrections custody, again with a 12-month post-release supervision duration. Court imposes no fine, but does assess $400 KBI lab restitution, a felony docket fee, and all bids assessments are waived, given the court's incarceration sentence.
Could I suggest maybe even sober living environment here in town? I mean, I'm just throwing that out there. That is one thing I have not been offered.
But
I mean,
look, you knew you were in big trouble when you were arrested on this case. This case has been pending for 7 months now, and only very recently you see the need to put yourself in treatment. Right?
No. I've brought that up several times to my attorney, and that's why we did the drug and alcohol evaluation, and then I started with my classes through Seventh Direction.
Mr. Weinbaugh, your attorney doesn't put you in treatment. You put yourself in treatment.
Right, but that's what I'm saying. I mean, I'm even willing to do that. That way I can still hold a job here in the community and still work my classes and show you guys that, you know what I mean, this steps that I'm, taking and show you guys and prove to you guys that, I mean, I can kick it. I can. I mean, I've not an issue with it. But
Mr. Weinbaugh, you've shown us guys nothing but methamphetamine possession and use. You've got a long track record of it, a track record which is continuing right up to today, it would appear. The court has already ordered a prison sentence, and the court will stand by that sentence.
Your Honor, if I could briefly be heard. Judge, if we could request, and I know that we're doing this on the fly, of course, but we would request the court consider imposing a durational departure for him, given the factors already listed, that he has almost no violent history, that he is essentially just, as the court well notes, had a very serious substance abuse struggle that he is losing consistently. 18 months is time to dry out, but he is not really a threat to the community. We'd request the court to impose a 12-month durational departure based on the previous factors we have listed.
Counsel, the court's already announced its sentence.
I understand.
So any request to post-announcement modification is denied. Again, there are no substantial and compelling reasons which warrant any type of departure in this case. Mr. Weinbaugh, with all of this said, if the Department of Corrections has any type of programming that would assist you in recovery and dealing with your addiction, please take advantage of any of that programming which exists. I don't know what will be available to you, what will be offered to you, but if the opportunity is there, I highly suggest that you follow through on what you claim you were going to do on the outside, but do it on the inside so that you're in the best possible position to succeed for yourself and your family when you get out.
Now, what about Seventh Direction? I mean, that evaluation, I mean, in Sydney's behalf, I mean, you know what I mean? Like I said, I'm telling you guys the truth on that. I don't know why she hasn't sent over the information to, like I said, I mean, and I did do that. And that's what we were waiting on last time. That was why it was continuous. I mean, and I did do that, but you guys haven't gotten that paperwork. I don't know why. Like I said, I did, sign a waiver with Cindy. Is there any way we could contact her? And that
No.
would, I mean,
No. Court will enter additional orders. The court will grant 1 day of previous jail time credit to be reflected in the sentencing journal entry. Mr. Weinbaugh, you may have the right to seek expungement of this offense in the future. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant, upon conviction, can appeal that conviction to the appellate court having jurisdiction. And if such defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal, and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal the sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Court orders the custody of Scott Andrew Weinbaugh and to the representatives of the Butler County Sheriff's Office until he can be transferred to the Department of Corrections to serve the remaining balance of the 18-month prison sentence which was imposed here today. Mr. Sweeney, are there any other sentencing-related matters that the court still needs to address?
No, Your Honor.
Mr. Favre, anything further regarding sentencing in the Weinbaugh case?
No, Your Honor.